What is a memorandum? Memorandums are essential in legal studies, criminal justice, and in investigations because they provide a structured way to manage complex information. Is that I noticed that legal studies focus on theory, policy, and interpretation of the law, while criminal justice explains the system, police, courts, corrections that manages crime. Meanwhile, there's a subsection of criminal justice, which is criminal investigators, are practitioners who apply these legal principles and justice systems to actively solve crimes and gather evidence. This, which is IRAC, CRAC. So the acronyms that I learned in my class, at least, this teaches you exactly what most memorandums would want you to write on, but there are always certain cases where you wouldn't really need this format, and this is just really the default recommendation, but there are other cases where they would make you kind of change the layout format just to adjust to it. And for example, if you're doing legal studies in torts, there are some cases where it would be formatted a little differently. So, getting to the point, what is IRAC? IRAC is issue, rule, analysis, conclusion, or CRAC is conclusion, rule, analysis, conclusion. This is really good for memorandums because it is a method for organizing legal analysis so that the reader can follow your argument. It's helpful in writing these reports and legal memos. So below here is an example provided by my University of Maryland Global Campus. They have provided at least about what this is about and provided a breakdown of what you can write in your typical memorandum. What you would do for this IRAC is you would put it into your memorandum format, and then after that, you would make sure it concludes to all the paragraphs. Your typical memorandum would kind of look like something like this. If anything, it looks a little bit wordy and long, but that's just the typical format. And you can technically shorten it, but you have to be very careful because of the fact that context really does matter. And if you don't get it, your statement with your evidence and conclusions all, together and compacted, then it will definitely change the meaning of the whole memorandum. So an example of how to do it is we will look at whether someone can sue battery as a result of inhaling secondhand smoke. And the issue we will look at is whether there is contact, which is required for a battery claim. So with this statement, we do understand what issue is. And most of the time, the issues are kind of like questions or problems you're trying to answer, what the parties bring into court, which is like plaintiff versus defendant. This can be a form of question or statement depending on what your reader prefers. Some examples are there is an issue as to whether contact occurred when the plaintiff inhaled secondhand smoke. Does contact occur when one inhales secondhand smoke created by another? Sometimes in legal memos, one may state the conclusion up front, but other times your professor can also make you state the conclusion up front instead of, for the rule, you must state the rule or legal principle. It can be any form of the elements, and you will use a certain database with your case laws to back it up. For this example, they're talking about the offense of battery requires contact with the plaintiff's person, etc. For your analysis, this is where you state your evidence and explain how you arrive at your conclusion. This can include any supporting evidence cited from the cases, statutes, laws, legals, principle, or policy implication, discussions that can counter your conclusion, and make sure you weigh both sides and counter arguments when appropriate. For instance, you can use a case law and policy example of a tort law, like below in Howe versus On. The court held that noxious bus fumes inhaled by a passerby constitute harmful and offensive contact. Although the court has not extended this holding to a case involving secondhand smoke, numerous cases have likened secondhand smoke to air pollution. For example, Fox versus Abernathy, etc., etc. I'm not going to read it whole, but I think you get the gist. And then for the conclusion, you're going to conclude based on all of it from the issue, the rule and analysis, conclude the final answer. So this final answer would be like, for instance, the court is likely to find that harmful contact occurs when smoker releases secondhand smoke into the air and that the air is inhaled by a bystander. So there is an exercise below. You can technically learn how to write it using this exercise if you would like. If not, I'm going to jump to the next part. So this next part, it would be, how am I going to use case laws and put it into a memorandum? What you would do is you go to Westlaw first, Westlaw Edge. And for this example, we're going to do something about Maryland laws for this case. And you can check through this database, basically like a database for legal research where you can find cases, court rules, statutes, regulations, etc. You can go through, federal materials, state materials, certain specific areas, regions, practice area. And if you want to understand more about the Westlaw, it is important to also understand more about the statutes of each case using key cite. An example provided by Westlaw Edge. These flags do tell you which is a good law to compare, to use for evidence and everything. For this case, I'm going to go back to the case that we're doing. We are talking about the car accident. So the car accident is talking about Woodbridge versus Price. And we're going to go to the database where it shows it. And because this case that we are analyzing is very long to write a memorandum is like a shortened version of it while using another case question. So we are using this case to back up another issues case. So example, we're having a car accident and we're wondering which one's at fault. We can use this case right here, Woolridge versus Price, as an evidence factor to conclude our reasonings for the current case that we're dealing with. And the current case that we're dealing with right now is the facts of this case. So I'll read this and then you can understand what's going on. So to write a memorandum, you should include the heading part and then the facts, the issue, the rule, like IRAC, analysis, and then the conclusion. So in this case, I'm going to explain to you what happened with our current case, and then we're going to apply that case law and other Maryland statutes and regulations, case laws related to it, onto the current case. So the facts was Mrs. Smith was driving on a winding location road in Columbia, Maryland, heading to her sister's house where the speed limit of the road was 30 miles per hour due to its geographic location surrounded by rolling hills and pastures. While driving, Mrs. Smith was distracted by the scenery and failed to notice that her car had drifted partially into the median strip of the wrong lane. At the same time, Mr. Klink, driving the opposite direction of 55 miles per hour, noticed Mrs. Smith driving into his lane. When Mrs. Smith noticed Mr. Klink's car, it was estimated that it was approximately 50 yards away. But Mr. Klink estimated it was approximately 100 yards away and stayed in his lane, hoping she would return to her side of the road. However, Mrs. Smith did not, and the vehicles collided shortly after. As a result of the crash, Ms. Smith suffered significant injuries, including a broken arm and back injuries, as well as $14,000 in car damage, $47,000 in medical bills, and $22,000 in income from not being able to continue working for 2 months. In contrast, Mr. Klink had $1,500 in minor damage to his vehicle and was cited for speeding at the scene. Mrs. Smith has filed a negligence claim alleging that Mr. Klink's excessive speed caused the accident, and Mr. Klink's attorney has raised the defense of contributory negligence, arguing that Ms. Smith's failure to maintain her lane of travel was the primary cause of the crash. So that seems very long, but it gives you a gist of what actually is happening. In real life, since I already had written all this IRAC format and the memorandum already done, they would give you a scenario of what's going on, and then they will ask you to take that scenario and find only the facts, the main ideas of what's happening, and put it into the facts section. And that's exactly what's happening right now. If you read this paragraph again, you can tell it's literally just talking about what actually happened and all the major and important facts that has happened currently in this scenario. In the next part for your issue, you're going to write what is going on and how it's related to the law that you're going to compare to the case. So basically, what is the legal question for this scenario? And the legal question that I have decided to write is, the issue is whether the last clear chance doctrine can be applied to overcome the contributory negligence defense raised by Mr. Klink, whether Ms. Smith is allowed to recover damages by her own contributory negligence, considering Mr. Klink had a last clear chance opportunity to avoid the collision after noticing Ms. Smith in his lane, and whether Ms. Smith is time barred from pursuing a complaint against Mr. Klink by the Maryland statute of limitations. So how I got this issue in the first place is that I went to do the legal research. I went to look for all of the head notes, which tells you each of the laws that's related to it, for instance, negligence. And I also went to go read the opinions, which is the facts and proceedings, standard of review. And then after a while, I looked at the main parts, which is this case, it was stated last clear chance doctrine. And it does define it right here. Exactly what I just explained about it. Does it completely bar against the recovery against a negligent defendant? So that is technically what it is. And like I just explained, you're using this case to help you support your evidence from the other case. So back to going on, the next part is understanding how to make the issue, which I explained. And you can do that using the other laws in the Westlaw. For this case, if I go all the way down to my citations, you can see you can apply certain laws into your issue. For my issue, I added all that while summarizing the laws that I'm using for this case. Going on to the rules section, for the rules, you're going to ask the question, what law applies to this scenario? And that's exactly what we just did earlier. We're going to go to the Westlaw database, and you're going to look through the case and analyze the case, which laws are most important to add to your case. And in this case, the two laws I noticed is mostly about last clear chance doctrine, negligence, and a couple other Maryland laws that were shown in the conclusion. Oh, right, it's right here. Maryland Code Transportation. And what you can do to find these codes is you would go to the headnotes and you will see the main codes of what law is applied to those scenarios. For this case, it's automobiles. Automobiles, and they give you a summary, like the main summary of the main gist of that law, how it's related to it. And these ones, I think, were already on the essay I put. And they have the citation down here. And if you go to it, it will definitely show you where the law is part of it. And here's another of the negligence. Going back to the essay of the memorandum, let's go over what I wrote. And this is a good, example of what a memorandum should be for the rule part of explaining the legal laws applying to the case. Under Woolridge versus Price, 184 MD APP, which is Maryland Appellate Court, 451 462 2009, the Maryland Court of Special Appeals breaks down the last clear chance doctrine, where it allows a contributory negligent plaintiff to recover damages if the defendant had the last clear opportunity to avoid the accident but failed to do so, and the following conditions are met based on West and MD Code Transportation statutes, this is the plural citation of statutes, and then the numbers are given right in the case right here that they show you right here below. And then you're going to cite it properly and then explain the law, which is, in this case, it states in the law that one, the defendant is negligent, two, that the plaintiff is contributorily negligent, and three, the defendant had a fresh opportunity to avoid the harm after the plaintiff's negligence set the events in motion and the defendant failed to take advantage of that opportunity, such as the defendant having a last clear chance opportunity to avoid the accident, and four, the scope of the party's action based on the type of vehicles and traffic regulations where the vehicle is any device in upon or by which any person or property is or may be transported or drawn on a highway. So what I just explained here is explaining the laws from those statutes. I just basically summarized it into the statutes, what you're going to do for the rule paragraph. And then below that, you're going to add one more, when in this case, since this new one, is not related to that regular code transportation one. Then it's going to be, in Maryland, contributory negligence is a complete bar to recovery and serves as a strong defense for defendants such as Mr. Klink. So you see, I added the case that we're using, and then I added how it's related to the current case that we're having, which is Mr. Klink versus Miss Smith. It has to relate to each other. And then you're going to conclude, like I just did, however, the last clear chance doctrine provides a narrow exception to this rule. Meanwhile, under Maryland Code of this judicial courts and judicial proctors or procedures, 5101 Westlaw, a civil action in Maryland at law shall be filed within 3 years from the date it accrues unless another provision of the code provides a different period within which an action shall be commenced. So this whole paragraph is just talking about the rule of what kind of rules are related to this case that I'm going to be explaining in the next part, which is the analysis and how it's being compared to the current one. For this case, I am using all these codes. I'm talking about the case of Wooldridge versus Price that I'm going to talk about, the last clear chance doctrine, these codes that I'm using to determine whether or not who's right or wrong for the case of the facts, and also including the civil action law, Maryland shall be filed within 3 years of the date. So what that's talking about is that sometimes you are barred from pursuing a complaint if you haven't filed it within 3 years from the date. So let's say this case happened and you filed it after 3 years, then you cannot file that action because of the fact that it's over the time limit of the code. Okay, now we're going back down to the analysis or application. And in this part, you're basically going to explain how the law applies to the facts, which is based on your rules and how it applies to your issue and why. It's basically explaining why you're asking this question and why are you using these laws to apply to it, just like your evidence from the previous two. For this case, I said, here, both parties were negligent since Miss Smith was distracted by the landscape and did not notice that she drifted into Mr. Klink's lane, and Mr. Klink was speeding at 55 miles per hour on a road with a 30 miles per hour speed limit. Noticing Miss Smith's encroachment to his lane 100 yards ahead, but stayed in his lane and did not avoid the collision. Since Miss Smith failed to maintain her lane due to distraction, Mr. Klink can raise a contributory negligence as a strong defense, which would ordinarily bar her from her claim under Maryland law. However, the key issue is whether Mr. Klink had a last clear chance to avoid a collision despite Mrs. Smith's initial negligence. Based on the facts, it suggests that while Miss Smith was contributory negligent, like drifting into Mr. Klink's lane, the last clear chance doctrine is still applicable if Mr. Klink had a fresh opportunity to avoid the conclusion after noticing her in this lane. So what I'm explaining is that I'm talking about what actually happened and why the last clear chance doctrine. So it's related to it. So what I did is the rule is breaking down of what laws you're going to explain. Usually most people would assume that you're going to explain it in order. For this type, I am explaining in order. I'm going to explain last clear chance doctrine and then the codes, and then after that, whether or not she's barred. Sometimes it might overlap, but most of the times by default, people are going to assume when they're rating it that it's going to go in order, so it will make more sense. So I'm explaining what actually happened and how it's related to last clear chance doctrine. And then I'm providing the evidence in this case. Firstly, there is Mr. Klink's negligence since he sped on the highway, which constitutes negligence under the case law and statutes. Mr. Klink's decision to drive at 55 miles per hour on a winding 30 miles per hour road was a clear breach of duty of care owed to the other drivers since the area required extra caution due to the winds. Moreover, his failure to avoid the collision once he recognized that Miss Smith's car was drifting into his lane was one of the negligence. Through the West Maryland Code, Transportation 21404, I'm not going to read all because it's quite long. It supports this claim where he didn't yield the right of way and avoid causing harm by speeding, which constitutes negligence under these circumstances. So the definition of negligence will depend on what kind of case you're using. And in this case, if you go back to Westlaw, they do define what this negligence is about. So right here talks about negligence. Another here talks about negligence. And then right here talks about negligence as well. These are not exactly word by word of the law, but it does tell you what they mean by how is negligence applied to this law. For this case, the doctrine of last chance clear chance prohibits a contributorily negligent plaintiff to recover damages from a negligent defendant if each of the following is satisfied. And what I did is I just analyzed the case and I used the law to analyze it and make an opinion about it. So that's first the code of the law of it. Secondly, since Miss Smith had failed to notice her drift into the wrong lane going into Mr. Klink's lane of traffic and her distraction of the scenery, it constituted a contributory negligence because the Maryland courts held that the contributory negligence on the plaintiff's part bars recovery against the defendant unless an exception like the last clear chance doctrine applies. So when you are writing these type of analysis, you can also provide counterclaims and also basically I explained earlier, you both see both sides of the circumstances and you provide counterclaims as well, or depending on which person it is, whether it's plaintiff or defendant. And thirdly, this element will analyze if Mr. Klink had a last chance clear doctrine to avoid the accident with Miss Smith based on the facts, since Mr. Klink saw Miss Smith's car drifting onto his lane when it was approximately 100 yards away. He decided to remain in his lane, hoping that she would correct her position, where the collision occurred shortly after he observed the danger. This is crucial to determine whether Mr. Klink had enough time to take action and avoid the crash. So now I'm going to explain about the last clear chance doctrine a little bit more related to the case, and that's what you're doing. I said in Woolridge versus Price, the court emphasized that Mr. Klink must have had a fresh opportunity to avoid the collision after Miss Smith's negligence put her in a position of peril. Specifically, Mr. Klink did observe Miss Smith's car in his lane, and even though he was speeding where his reaction time is limited, it can be argued that he had sufficient time and space to take evasive action. So I'm explaining about more in depth about the last clear chance doctrine and explaining another more about how it's related to this new case that I'm using as evidence to back up, and also the new codes that are added to it. Through these transportation codes, for Maryland, a driver has a duty to act to avoid an accident when another vehicle is in a dangerous position. Given that Mr. Klink had time to react and choose an alternative, such as slowing down or swerving, his failure to do so suggests that he did not take the necessary precautions, which invokes the last clear chance doctrine. Based on the facts of the actions in the case were sequential, not concurrent, which is crucial for the last clear chance doctrine to apply, where the defendant must have had an opportunity to avoid the collision after the plaintiff's negligence was already in motion. Since Miss Smith drifted into Mr. Klink's lane, Mr. Klink had the opportunity to avoid the crash but failed to do so. And unlike in case Woolridge versus Price, where the plaintiff's negligence occurred at the same time as the defendant's negligence in this case, Mr. Klink had the opportunity to avoid the accident after Miss Smith's initial negligent act of drifting. Mr. Klink's failure to take any action could be viewed as a failure to exercise reasonable care under the circumstances. Fourthly, based on the scope of the parties, the action and the type of vehicles involved in relevant traffic regulation, Miss Smith and Mr. Klink were operating motor vehicles on a highway where all traffic rules like speed limit, lane usage, and the right-of-way are accounted for in the scope's examination. So this is the last part where I'm talking about it and including more of the statutes and regulations with the case. For Woolridge versus Price, the courts held that any driver must comply with traffic regulations of the highway. In this case, both parties failed to comply with traffic regulations, such as Miss Smith's failure to maintain her lane, and as is a violation of a duty to her care, and Mr. Klink's speeding is a violation of traffic laws. These actions are important as it is also considered for the third element based on the last clear chance doctrine. Furthermore, since Miss Smith's failure to maintain her lane due to her distraction, Mr. Klink can raise contributory negligence as a strong defense, which would ordinarily bar her claim under Maryland law. However, the key issue is whether Mr. Klink had a last clear chance to avoid the collision despite Miss Smith's initial negligence. Through the Maryland Code 5101, which is Statutes 5101, it allows her to file her claim within 3 years of the event, which is completed by the fact that she filed this report after the accident, meeting the requirements. So with all these evidence, I am explaining the breakdown of the issue. And for the conclusion part, which is the next part, is you're going to conclude the final answer based on all these evidences and answer the issue question. So the issue is this part, right? Is there any way the last clear chance doctrine is applied? And which of the party, which is Ms. Smith's this case, is allowed to recover damages despite contributory negligence. So because of this, I have written the conclusion part. I wrote in conclusion with this case, Woolridge versus Price and the statutes makes it arguable that the last clear chance doctrine applies to Miss Smith's case, allowing her to recover damages despite her contributory negligence. Even though Miss Smith's negligence contributed to the accident, Mr. Klink was speeding on the highway and had the last clear chance opportunity to avoid the collision after seeing Mrs. Smith's car in his lane and failed to take appropriate action to prevent the collision, which may allow Miss Smith to recover damages despite her contributory negligence. Therefore, the court may find that Mr. Klink had the last clear chance opportunity to avoid harm, and Miss Smith could be entitled to recover damages. Therefore, while Mr. Klink's strongest defense is contributory negligence, which under Maryland law generally bars a plaintiff from recovering damages, the court may nevertheless find that the last clear chance doctrine applies since Mr. Klink had the last clear chance opportunity to avoid harm, allowing Miss Smith to recover as she filed the action within 3 years. Statute of limitation under the Maryland Code. Courts and Judicial Procedures, Statutes 5101 Westlaw, despite her negligence. So the key parts of writing this memorandum is doing the IRAC, which is what I just did, or you can do the CRAC. And what you want it to do is you want to make it keep organized legal writing, make arguments clear, and explain how it reached this conclusion. And you don't really, need very complex sentence wording. If anything, you wanted to make it in plain English as much as possible because the person reading it doesn't really have the knowledge to mind read of what's actually going on. They just want the key parts of each of the scenario and you explaining how the law is relevant to those key parts. And I do notice that memorandums in general, when I'm taking these classes, they do care a lot about citation in particular. You have to learn how to use the Blue Book citation. So if we go up here, Blue Book citation, everyone knows the Blue Book citation. Let's see if so the Blue Book citation teaches you how to write an APA style basically and cite it. And you want to do is you want to cite the in-text citations and APA citation and according to exactly what the Blue Book does for those cases. So as you notice, I did put the case right here, incorrect citation, as well as the statutes, and also including this part of the statutes. And the reason why you have to add this Westlaw through all legislation from the regular 2024, it's because it's part of the code itself. It's basically telling where it's coming from, and you have to keep it that way because we got it all technically from Westlaw Edge here. Yeah. So let me see. I can explain what I mean. I can just take this code. Yep. All right, here. Okay, so you notice at this code, it does show you where it is. It says Maryland. So we got it, courts and judicial proceedings, civil actions. And if you notice that it does explain it right here, filed within 3 years. And then at the bottom, it says right here, this is what you want to see. Current with the legislation effective through February, blah, 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 regular session of the General Assembly. And the correct way to write this, instead of using the weird citation that they're giving you by default, is to go use the Blue Book format. And the Blue Book states to use this format right here, correctly like this. Yeah, it's a bit very wordy, but I believe that is the way that they're asking us to cite it, at least. And we're going to do all the references. So these are the references I got from my lectures and what the definition of each tort law is related to it and how it's related to the case as well, the current case she gave us, which is about Mr. Klink and Ms. Smith. And then these are the citations of relating to the case and the statutes and regulations, how I'm going to use as evidence to supporting evidence for my claim of my issue. Yeah. All have to be proper citation, all proper in Blue Book format. And the other part of citation is also line spacing. You want to make sure it's 2.0, double spaced. Other memorandums like criminal justice and criminal investigator memorandums, they use a different format, if anything. So legal ones focus on lawsuits, liability, damages, plaintiff versus defendant. And criminal justice doesn't focuses on criminal law and violations, offense and evidences, and then written for supervisors or prosecutors usually. It includes something similar format, but it's more like facts, issues, applicable law, analysis, and conclusion. Focusing on did a crime occur, what laws were violated. Or criminal justice or criminal investigator memorandums usually, they would do something similar, but instead you are focusing on evidence, probable cause, violation of the law, investigative conclusions. So if you want it simplified, legal studies focus on civil liability, lawsuits, damages, criminal justice focus on criminal violations, charges, investigators focus on evidence, probable cause, investigation findings. So that's about it. And the second part here I will explain is the format of how it would look like for written for a criminal justice memorandum. Quite similar. It's just you're shortening most of the stuff and getting to the point like I explained for the differences between those three. Notice that they are using bullet points and also writing it more shorter. Notice that the difference is mostly in the analysis portion, where each has their own focus, where criminal justice mostly talks about criminal violations and charges, like what kind of law did you break and other stuff. Very similar. It's just I felt like maybe most people wouldn't be that detailed, but I'm very like detail oriented, like in a sense where I prefer more details so that it would be more clear for the person to imagine and understand what's going on in that scenario. References would be kind of similar. I'm not sure if they do use Blue Book, but if they do, then it would be in this format. Otherwise, it would probably be in a different format. What I find very interesting is that they're very different. So over here does explain about the differences about it. You can tell that the purpose of the memorandum in legal studies is to analyze or legal liability and predict court outcomes. Used by lawyers, law clerks, legal assistants, law students. Focus on lawsuits, tort, liability, contract disputes, civil damages. Can the plaintiff recover damages? Does the statute allow a lawsuit? Will the court rule for the plaintiff or defendant? And then for this case, you can do an example whether Ms. Smith can recover damages despite contributory negligence. For criminal justice people, they're different. They're like analyze criminal misconduct, probable cause, and violation of the law, used by criminal investigators, federal agents, detectives, prosecutors, intelligence analysts, crimes, evidence, criminal statutes, charges, investigative decisions. Did a crime occur? Probable cause, criminal charges may apply. What evidence supports prosecution? Did Mr. Klink commit reckless driving or negligent driving under Maryland law? Types of laws being applied. You can show this. So these are examples of laws being applied. for legal studies, mostly civil. And then criminal justice, you can do more of that, which is related to criminal charges, assault, fraud, reckless driving, homicide, theft, etc. For the issue written for legal studies, whether the last clear chance doctrine allows Ms. Smith to recover damages despite her contributory negligence, civil recovery. That's talking about civil recovery. And then criminal justice focus on criminal violations, whether Mr. Klink's excessive speed or failure to avoid the collision constitute reckless or negligent driving under Maryland law. The memo will look something similar to this. Legal studies is right here. The format for the heading. Format heading for the criminal justice will be here. And then the comparison chart is right here for all three. Here's the special agent or criminal investigator part. It would write it something like this. And notice that's very different. They add purpose to it for some reason. Let's see, huh? Yes, they add purpose at the top. Which you do write that in memorandums too. In the introduction memorandum courses, they do teach you that. But in general, you wouldn't really be writing that part in general for legal cases because of the fact that they're not really asking you the purpose of it. They're mostly going to go straight forward to asking the issue. Yeah. So I guess their way of doing issue, which is the issue part in the IRAC, is calling it purpose to make it more simple. I would say they're more straightforward wise and focusing on a different part of the law versus the legal studies one would focus more on liability, damages, and plaintiff versus defendant kind of type. So, yeah. Notice quite similar. Very similar. Very similar. I'd say the application analysis would be quite a little bit different because one is focusing more on about liabilities and the other one is focusing about what laws did you break and probable causes of those issues correlated to it. Yeah. Notice the conclusion is also very different. Therefore, the evidence suggests both drivers engaged in conduct that violated traffic safety standards and contributed to the accident. Additional review of witness statements, accident reconstruction reports, and roadway condition may further clarify the extent of each driver responsibility. So you see how the conclusion is very different from the legal studies one, because the legal studies one, we're concluding about whether or not the person can file a lawsuit and the damages between the two, because it's talking about recovery. In this case, for criminal justice people or criminal investigators, you're talking about what caused it and the evidence that caused it. Like example, one of them caused the accident. I need to find evidence about why, who caused it first or whatever, or which laws they violated. For this case, it does show that they both of them violated at least and contribute partially to it. And then they would need to conclude using witness statements and accident reports to see if which one is the driver's responsibility for it. Yeah. But most of the time, you won't really see this type of case for a car accident related to criminal justice people because that's not what they're really focusing on. If you're talking about assault, criminal offenses or charges like murder or theft or something like that, you're most likely going to see most of those memorandums similar to what a criminal justice or criminal investigator would write. Legal studies would be less of that. For my focus, I didn't really focus on those portions. There is a section of legal studies where you could technically write a memorandum similar to that. But for my case, I was more focused on torts, which is more about civil liability and lawsuits, which is typical for legal studies class or major because you're talking about defendant and plaintiff in this case. or if they lawsuit each other. For police or detective reports or investigators, intelligence analysis, they're most likely not really asking who's lawsuiting each other. They're mostly going to investigate who's mostly going to be at fault for the causation of it, and also what laws did they break that caused it. So if anything, I feel like you're basically doing a memorandum about lawsuits for law people, and then you're doing a memorandum for about criminal violations and charges in criminal justice, basically. So that's about it. And other than that, that is exactly how you should write your memorandums format. I do think that memorandums focus a lot more on citation though. I hope this video was useful. If anything, I will provide a lot more educational videos related to any of the classes I've been taking or anything in general, whether it's coding or legal studies or criminal justice or, I don't know, programming, cybersecurity, IT. Well, that's about it. If you have any questions, feel free to subscribe and ask below. Thank you for watching.